Article 3 gives us the last branch of the federal government, the courts. Actually, it only gives us the Supreme Court. Whether there are lower federal courts at all depends on Congress. What is the Supreme Court supposed to do? It's supposed to decide cases, but not just any case. The Constitution sets out the kind of cases the court can hear. And basically, these are cases where you can't leave it up to state courts, just like Congress can make laws where you can't leave things up to state legislatures. The Supreme Court can hear cases about federal law, where we need to have one interpretation for the entire country, not one interpretation in Texas and a different one in California. And it can hear cases where you might not trust a state court to be impartial, if one state sues another, for instance. So the Constitution doesn't say, settle all our divisive social issues. It doesn't say, be the conscience of society. If the court is going to do that, it's because of what it thinks is in the rest of the Constitution, mainly the amendments. What the Supreme Court is doing as far as Article 3 is concerned is mostly making sure that federal law means the same thing in different parts of the country. It's resolving disagreements between different lower federal courts or different state courts about the meaning of federal law and the Constitution. And of course it has to wait for cases to come to it. The Supreme Court cannot reach out and do something on its own initiative just because it thinks it's a good idea. Courts are passive, not active. And in that sense, they're weaker than Congress or the President, who can initiate actions on their own. In another sense, though, the court is stronger. It has the power to strike down a law. It can say to Congress, you think this is a good idea, you think this is constitutional, but we disagree, and your law is no good anymore. It has the power to order the President not to do something. You think you can seize the steel mills, Harry Truman, but we disagree. Give them back. The court has the last word on the meaning of the Constitution, and so it gets to tell the other branches of government what to do. But will they listen? This is the real test of the court's authority. When it speaks, will people obey? If they don't, there's not much the court can do. Congress controls spending. It can take money away from programs it doesn't like. The President has the FBI and the Army. He can use force to get his way. But the court has nothing but its orders, pieces of paper. And those have power only as long as people believe they do. In the court's early days, it was not as respected as it is now. It met, not in the majestic building it has now, that wasn't built until the 1930s, but in the basement of the Capitol. One early justice resigned to take a position on the more prestigious Supreme Court of South Carolina. And its early decisions weren't always respected. There was a dispute between the Cherokee Nation and the state of Georgia. Georgia, to put it simply, was trying to take the Cherokee land. The Supreme Court said, no, you can't do that. The land belongs to the Indians. But Georgia ignored it, and so did the President. The Cherokee were driven from their land along the Trail of Tears. Many of them died. Enormous hardship, enormous injustice, and the court was powerless to stop it. Listen to what Justice Breyer has to say.
The Supreme Court decided that this land belonged to the Indians. That's what the treaty said. The land belongs to the Indians. Georgians leave.
To the Cherokee, this settled the entire question.
But Georgia officials simply ignored the Supreme Court's ruling, and so did the President.
Well, that's the case about which President Andrew Jackson supposedly said. He might not have said these exact words, but he said quite a lot like it. He supposedly said, John Marshall has made his decision. Now let him enforce it.
But things changed. In 1953, the court issued another decision that states didn't like. In Brown v. Board of Education, it ordered states to desegregate their public schools. The southern states responded with massive resistance. 101 Southern members of Congress signed a manifesto denouncing the court's decision. Southern governors vowed to resist. Orville Faubus, the governor of Arkansas, mobilized the National Guard and surrounded the schools of Little Rock to stop integration. State troops blocking the entrance of the black students.
The popular sentiment was raging, and it was in favor of segregation.
And the governor just rolled that tide as much as he could.
We are now faced with a far different problem, and that is the forcible integration of the public schools of Little Rock against the overwhelming sentiment of the people of the area.
A federal district court in Arkansas ordered the National Guard to stand down, and they did. But the police who replaced them were unable to control the crowds. Without some intervention, the Supreme Court's desegregation order would mean nothing. So President Eisenhower sent in the 101st Airborne. People of Arkansas wouldn't obey the court necessarily, but they'll obey the Screaming Eagles.
Not responding to an earthquake, not responding to some natural disaster. He says that I'm going to send men in there armed and prepared to shoot and kill if necessary to protect the constitutional right of these children to go to school.
We are a nation in which laws, not men, are supreme. Our personal opinions about the decision have no bearing on the matter of enforcement. The responsibility and authority of the Supreme Court to interpret the Constitution are very clear.
If force is required, that's where it has to come from, the other branches of the federal government, Congress, and the President. That's the difference between the Cherokee case and the Little Rock one. The President didn't support the court in Georgia, but he did in Little Rock. Now, should Congress and the President follow the court? The Supreme Court issued an opinion about Little Rock later, in the case of Cooper v. Aaron, and it said that the court has the last word on the meaning of the Constitution. Everyone else is bound by what we say. And certainly that makes sense if we're talking about the states. Otherwise, we'd have 50 different interpretations of the Constitution. But what about the other branches of the federal government? I've given you 2 good decisions here, but the court has made some bad ones too. Ultimately, the reason people obey the court isn't because we think it makes all good decisions. It's not even because we think the court gets it right more than the other branches. It's because, good or bad, right or wrong, we believe those decisions are independent. We think they're based on the justice's best understanding of the law, not political desires or pressure from other sources. The Constitution goes to great lengths to make sure that judges are independent in this way. It says they serve for life unless impeached, and their salaries can't be reduced. This independent judiciary is an important feature of our separation of powers. It's probably the most important at this point, because of the effects of the party system. One political party can take over the presidency and Congress pretty quickly, and once it does that, you won't get much checking and balancing. But the Supreme Court is much harder to capture. Because justices serve for life, a political party has to hold the presidency for a long time to be able to appoint enough new ones to control the court. So that's what the court does under the Constitution. It gives us uniformity in the interpretation of federal law and the Constitution, and it also gives us a third power center for the separation of powers. It resists the effect of the party system better than the other branches. It can check Congress and the President. It can protect your rights. What are those rights? Well, that's what we take up next time.